first case to come before the court today is State of Ohio versus Stephen Blake. Is it Sharier?
It's Shire. It's
Shire?
Yeah, he corrected me.
All right.
Early on.
All right, before we hear, let's see, each party will have 15 minutes to present its arguments. Appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and you do plan to reserve time, please let me know when you come up so I can mark that time. I'll do the best I can to keep you apprised of your time. The arguments are being visually and audibly recorded to be posted online, so please stay behind the podium and keep your voices up. Do not use the name of children in your arguments. Just refer to girl, daughter, victim, initials, child, anything but the name. We've read your briefs and we are ready to proceed when you are.
Thank you. Honors and truth. Just housekeeping, I already eliminated any reference to the victim other than by initial.
Thank you.
I was going to do that anyway. This is David Gedrock. I'm the attorney for the appellant. I would like to reserve up to 10 minutes. 5 minutes is fine.
All right.
Whatever I can.
5 minutes.
Thank you. May it please the court. This case involves a young woman, a friend of the family, who has a history of making false allegations of sexual abuse and accusing my client of engaging in an unlawful sexual conduct with her, which resulted in being tried and convicted. I made 3 arguments. The first argument was a sufficiency argument. The test in a sufficiency argument is whether the state met its burden at trial. Was the case proven beyond a reasonable doubt? The state's case was primarily Kay's bald, unsupported allegations. There was no evidence of physical evidence. There was no evidence he picked her up at the school or dropped her off at the school. There's no evidence that she reported the incident to anyone. The details about the event are pretty much almost template driven. She doesn't know the house address. She doesn't know the color of the house. She doesn't know the clothes he wore. She doesn't know what perfume or cologne he or she was wearing. She testified at one point that she'd never been in the house, never used the bathroom when she was over there, yet other people disputed that and testified that she had been in the house. So she should have had more detail about the house, but she didn't. The only evidence the state presented, and I'm using evidence in quotations, was that second letter that was manufactured once it became obvious that without an allegation of a sexual encounter, her reports weren't going anywhere. The police weren't taking it, and the CAC or CBS, whatever it's called down here in Wayne County, and I apologize for that, wasn't going to follow up on it. In fact, they even told her, there's no allegation of sex in here, we can't take this or go any further. But suddenly, after knowing this, she manufactures a letter that has that reference in it. Beyond a reasonable doubt is a high standard of proof under the law, and that wasn't met in this case. We have the bald allegation weighed against the lack of evidence and details. It's my contention that the court should have granted my Rule 29 motion based upon that. My second argument, the case also erred when it incorrectly applied the rape shield law to this case, and in doing so kept out Kay's prior false or inconsistent sexual abuse allegations and the testimony of the CAC workers. The CAC workers are forensically trained interviewers who, because of their training, are experts who are qualified to assess the veracity of and determine if there's substantiation to the allegation.
Counsel, the state concedes that rape shield was inappropriately applied.
Okay, well, thank you.
And you suggested in your brief that perhaps that there wasn't an objection. I understand there was an objection to the evidence, but
Yes.
it wasn't an objection based upon rape shield per se.
Well, not per se, but I objected to his ruling that he was going to keep out the evidence and he was going to keep out the testimony from the CAC.
So how do you have plain error here then?
Because I think it was blatantly wrong. I mean, it really violated my client's rights. He could have, there was so much in this record that had to come in and would have really affected the outcome of the case. There's a reference in there, for example, where it's noted that she is known to make up allegations to get attention. And that goes toward, one of the things the state always argued was extrinsic evidence, but extrinsic evidence can be used if it goes toward another legitimate purpose, like to show motivation to misrepresent or to lie or to have bias. These issues should not have stopped me and my client from being able to explore the true nature of her veracity, and not just from an extrinsic evidence purpose. So when he refused to let that in, I think that denied my client the complete opportunity to present the whole case that he should have had, and to give the jury the complete idea of the evidence in the case that the type of person we're dealing with here. A young girl that has a history of not telling the truth. And I'm just going to argue that experts aren't just necessarily people who have, like doctors and scientists, CAC workers who have specialized knowledge and experience in recognizing abuse. Had they been allowed to testify, the defendant would have had an opportunity to explore the reasons behind case testimony, to see if there was an ulterior motive, and to explore the underlying relationships.
Well, counsel, I think the state is saying, I admit that this happened, like Judge Callahan said, that the rape shield law shouldn't have been used, but how are you prejudiced? Because it's my understanding that they did a controlled call, and he never said, I didn't do it. And he said he knew it was being recorded. Why in the world wouldn't you say, I didn't do it? I didn't have sex with you. What are you talking about?
That's a good question. He mentions later, when I put him on the stand, that he was shocked. He wasn't sure what his feelings were. He was surprised. And he said, 20/20 hindsight, well, yeah, I agree. I should have said I didn't do it, but I didn't really know what was going on. All of a sudden, I hear from somebody I haven't heard from in 9 months. I'm listening to somebody making these allegations on the phone. I'm in a very small room where anyone else can overhear, and they're going to be interested in what I have to say. I didn't need, and he testified about the problems he was having at work, people calling him, names, scratching out his picture, and all these other allegations, asking, well, how old is his date going to be at the picnic and stuff like that. So he's concerned, and so he's contained. He's kind of shocked. He didn't know what to expect. He admitted he probably should have said something.
What could be more concerning than a 14-year-old accusing you of having sex with her?
Well, he didn't come out and say that he did either. That's one of the things I made too in the argument. He says, I said, did you say, I can't wait till we can do this again? No, I enjoyed it. It was so much fun. Let's do it again. No, he doesn't do that either. But the state seemed to think because he didn't come out and say, oh, I didn't do that. What are you talking about? That's more overwhelming or more convincing than the fact he didn't follow up on it and say, because she asked him, what part of it did you like? And he doesn't say, oh, I really liked it when we started kissing her. And he doesn't answer that question either.
Well, he said, though, we had other employees all around him. So obviously you wouldn't go in detail with that.
Same
But you
reason
could
why-
say, I really don't know what you're talking about.
I admit he should have said that. He admits he should have said that. But he was shocked. He was angry. He was upset. He had a lot of emotions going through his mind. And at that point in time, he wasn't in a position to think as clearly as he would an hour later, 2 hours later, and said, I should have said that. That's just a natural reaction. Something that's cut aside.
Well, a jury, though, could look at it and say the natural reaction is to say, what are you talking about? I never did anything to you.
No, I understand. The jury seemed to think that was important. I did the best I could to argue that he also didn't say, hey, let's have this do it again either, too. So, all right. But anyway, the argument I'm making is the record should have come in, so he should have had an opportunity to cross-examine her. And so the jury could have learned the whole story, especially since, like I said, there's records in there where she has been accused of making things up just to get attention. And then when you have these issues that you're having problems with faith, and then she's with this other mother, this second stepmother, and she's trying to have a good relations with her. And after 4 times the night before, when the mother is saying to her, anything happened, suddenly the manufactured letter comes out and says, I lied to you, I'm sorry. We had sexual encounter. Okay, I'm going to go on to my third argument. So we kind of argued the second argument. This was the first time Steve was ever accused of a sex offense, and there's no reason to believe that he would be a future sex offender. It happened one time. There was no evidence that he pursued her. There was no evidence that he encouraged her to love him, or that he said he loved her. There was no evidence that she was psychologically damaged. Prior to pursuing the case, she hadn't been to a counselor. She hadn't ever told anyone what happened, and this was for 9 months. She was in his presence after the alleged allegation because he wrote the letter. So she could go to the school, leave school and do whatever she said she needed to do. See a counselor, find out she was really pregnant or whatever. And he saw her 2 weeks later. After this alleged incident, she didn't shy away from him. She didn't say, Steve's coming, I'm not coming. She reacted to him like she'd always reacted to him before. Steve wrote the letter so she could get out of school. Steve didn't set it up. It wasn't part of an elaborate plan. It was her suggestion. So without these elements, we also feel that the court's maximum sentence doesn't conform to the Ohio sentencing guidelines and is another error for which this case should be reversed.
Counsel, I guess where I struggle a little bit here is twofold. First of all, you're not disputing that the judge gave him a letter within the, a sentence within the legal bounds, correct?
No.
Okay. Second fold is, it's almost sounding to me like you are arguing she was not raped, therefore she should not have gotten a sentence like this. You're suggesting that she brought this on. Let's just, for sake of argument, go with that. This is unlawful sexual conduct with
Correct.
a minor.
Correct.
The law kind of puts the burden of common sense on the adult.
I agree.
So I'm not sure how these arguments about his sentence, what you're saying now, fit in.
I'm not saying that she was raped. In fact, when she made the allegation of rape, the police didn't believe her either. They didn't follow up on that. What I'm just saying is that a lot of things the court looks at to protect society from the perpetrator, and they are supposed to use them in applying the sentencing guidelines, don't necessarily apply in this case. That's the point I'm trying to make. What I have is a man who had one allegedly sexual encounter with a woman, nothing before, nothing after, didn't pursue her. It just happened at one time. And because it was not a rape and because of her history, I'm not saying that, you know, that she deserved it or anything like that. It appears like she was a willing participant. She doesn't come out and make these allegations immediately afterwards.
But
And
this
she even
defense
says-
doesn't require you to be unwilling, does it?
I understand. I'm just making some points on my client's behalf.
All right.
Whatever time I have left, I'd appreciate it. Do I have 5 minutes?
You have 3 minutes and 54 seconds.
Okay, thank you.
I apologize for not letting you know you were getting close. I was too interested in your argument.
Thank you. I played it safe, and I think I saved a short wrap-up. So.
All right.
Good morning, Your Honors. May it please the Court, Andrea Uller for the State of Ohio. Essentially, Mr. Sharier has urged this Court to find that the evidence was insufficient to convict him of violation of RC 290704, not on the basis that the state failed to meet its burden of production on trial, but to quote Mr. Sharier, on the basis that, quote, mere oral or uncorroborated allegations should not be considered adequate to get a conviction, end quote. However, as Mr. Sharier conceded, the law does not require corroborating evidence. In the present matter, the evidence showed that Mr. Sharier, a friendly friend, wrote KW, a 14-year-old minor child, the note excusing her from school, signing as someone else's name. Evidence showed that he picked her up, he took her to his empty house, he kissed her, he grabbed her by her wrist, pulled her into her bedroom. He was actually convicted of the enhancement because he's more than 10 years older than this minor child, and he proceeded to undress her, undress himself from the waist down, and had vaginal and oral sex with her and penetrated her digitally. Further, although the law does not require corroborating evidence, Mr. Sharier's own statements during the controlled phone call on October 18th of 2016 corroborated KW's version of the events. On that date, KW used her father's phone to contact Mr. Sharier to discuss the events that took place on December 8, 2015. In the phone call, Mr. Sharier told KW that he was not real happy about the love letter that KW's stepmother had found that she had written, but had never delivered to Mr. Sharier. Mr. Sharier also stated that he was worried, and when asked if he remembered anything at all about them having sex, he said, "I remember that day very, very well."
Well, I think she asked him, though, didn't she? Do you remember that day? And he said, I remember that day well.
Yes.
Not necessarily responding to, remember the day we had sex. Don't get me wrong.
Yes.
An argument can be made that all those responses were ambiguous from him, but he never did really admit to having sex with her.
That's correct, Your Honor. He did not admit, however, basically at trial and throughout his brief, he's never disputed that the state did not meet its burden of production, that he engaged in sexual conduct with KW, nor has he disputed that he was aware that KW was 13 years of age or older, but less than 16. Essentially, he just argues that KW's version of events is not credible because KW herself has, in their minds, credibility issues.
Counsel, when he took the stand at trial, he didn't deny having sex with her?
I believe his version of the events has been that he did not explicitly state that he had engaged in sexual conduct with KW, but the circumstantial and the evidence in the case showed her version of the events was corroborated, was more credible than his version of the events. I believe his actual testimony and his argument is essentially that he remembers that day because he wrote her a note to excuse her from school, and he admits to the conduct of excusing her from school but not engaging in the actual sexual contact. So yes, and I would be misspoken to say that he doesn't dispute that he engaged in the sexual conduct, but he overall, that would be the only element of the offense that we're left to look at, and that's where the state,
Okay, go ahead.
the trial court obviously has the credibility of witnesses for the trier of fact to determine.
So he admitted that he wrote the note for her, supposedly to help her,
Correct.
because she thought she may be pregnant, and she wanted to go somewhere to get checked out. But that's all he admits. He denies having sex with her.
Correct. Essentially, given that the state proved all of the essential elements through the victim's testimony, the notes that were introduced, the controlled phone call that was introduced, and the evidence was sufficient to convict Mr. Sharier of unlawful sexual contact with a minor. With respect to Mr. Sharier's second argument, Mr. Sharier argues that the court should grant him a new trial because the trial court applied Ohio's rape shield statute to the charge of unlawful sexual conduct with a minor. As Judge Carr has pointed out in my brief, we conceded that RC 290702D does not have that explicit language that it would apply to that section. However, as this court has also pointed out, and defense appellate's counsel has pointed out, there was no objection raised on this basis at trial, and so the standard of review is plain error. And in this second district case of State v. Smitty, which is very factually similar to the present case, the second district viewed it as harmless error because the key issue in unlawful sexual conduct with a minor case is whether the defendant engaged in sexual conduct with a minor victim, and whether the point of the rape shield statute is to keep out prior sexual conduct with other defendants, and that would be irrelevant in this situation. And essentially, there's no marginal or probative evidence that would have been added by permitting Mr. Sharier to cross-examine KW regarding her past sexual encounters. And since the trial court has the latitude to admit or exclude evidence, and this evidence would have been properly excluded under evidence rule 403A as being inflammatory character evidence that is more prejudicial than probative, and would basically be
But when you have a
unfit.
case that's mainly credibility, wouldn't an argument be made that it was prejudicial for the jury not to be able to hear that the victim has made false allegations in the past?
I think that the precise reason that the rape shield statute exists is to keep that kind of character.
Of course, and I
evidence.
agree with you, but you already conceded the rape shield statute doesn't
Right.
apply,
And-
so.
But the rape shield statute has the same basic premise when that marginal, while that may be remotely relevant, its prohibitiveness is substantially outweighed by that unfair prejudice, and that would be the same under the 403A. And so when you have a case that's based on the credibility and the trial court is, the standard is abuse of discretion when they're looking at it, and they determine that that evidence is more inflammatory and prejudicial than probative, then I think it's proper to exclude.
And I'm sorry.
No, go ahead.
I understand your argument, but I guess my problem is the court really didn't look at it that way because the court said, I can't let it in, it's under the rape shield law. So it really didn't do any weighing of the evidence to determine if it was more inflammatory than probative.
And that's where I would direct this court back to State v. Smitty, because that same scenario occurred in that case. It was the rape shield statute that was applied rather than evidence rule 403A, and the appellate court said, we recognize that was error, but it was harmless because it would have been properly excluded under this basis. So I think it's still proper because the standard would have to be that abuse of discretion and reasonable, arbitrary, capricious, and we don't have that in this case for excluding this testimony. And also there was the in-camera review, and the trial court heard the testimony that was the appellant was trying to admit, and he found that the claims weren't completely unfounded, but he still excluded, although using the rape shield statute, he excluded finding that he could have arguably also taken in that balancing test. And lastly, with respect to Mr. Sharier's argument with respect to the maximum prison sentence in this case, as this court is aware, it may only vacate or modify a felony sentence if clear and convincing evidence supports that the trial court's findings were not supported under the relevant statute where the sentence is contrary to law. In the present case, the trial court considered the oral statements of the victim made during the sentencing hearing, as well as the principles and purposes of sentencing under the 292911 and the factors for recidivism under 292912, and determined that the maximum sentence was proper here. Mr. Sharier took advantage of and violated a 14-year-old child. He knew the emotional state of the victim. He had a prior conviction for robbery, and that is properly considered. It doesn't have to be, Mr. Sharier argued, this was his first conviction for a sex offense case. He was convicted and had a 9 to 25-year sentence on that robbery conviction. And so I think the trial court properly looked at all of those factors, and the sentence is neither unwarranted or clearly and convincingly contrary to law. So in conclusion, it's the state position that this court must weigh the evidence of whether Mr. Sharier engaged in sexual conduct with KW. Mr. Sharier's only argument is that his version of the events is more credible than KW's. However, when construed in a light most favorable to the state, there is sufficient evidence to convince an average person that Mr. Sharier was guilty. Further, while it may have been an error that the trial court excluded KW's alleged past sexual history and allegations against her brother under Ohio's rape shield law, the error was harmless because whether the victim engaged in sexual conduct with others is irrelevant, and any probative value is substantially outweighed by the danger of unfair prejudice to KW. And the trial court's imposition of the maximum prison sentence of 60 months in this case is neither unwarranted nor clearly and convincingly contrary to law. Thank you, Your Honors.
Say 3 minutes and 45 seconds, Your Honor?
No, 3:52.
Oh, okay. I just want to hit a few points in before I conclude here. There was no evidence ever presented that he picked her up or dropped her off to school. They didn't have the cameras to prove it, so that was never established. I thought I heard counselors say something to the contrary. I apologize. He did say he remembers that day well, but nobody followed up with what he meant by that. What did you mean by that? the police officer admitted he didn't follow up on that. So that's another point. This case, my client's conviction should be reversed. It shouldn't be remanded for a new trial. If we remand it for a new trial, the state gets to plug their holes. They get to find out what they have and try to do a better job. They got their shot. Trial's not a rough draft. They don't get a mulligan. My client was unduly prejudiced by the refusal to let in the evidence either from the reports or the testimony of the workers. The presumption in these cases, always that the defense has to overcome is, why would she lie? That's always one of the first things defense always has to overcome. In this case, we had evidence that we could have presented that would have showed that she is not an honest person, that there is an issue with her credibility. We could have presented an answer to why would she lie, but we didn't get that chance, at least not to the full extent we were entitled to under the law, but for the improper application of the rape shield by the judge. That's what should have come out. The whole case should have come out. Not, this watered-down version that fit into the preconceived notion of the jury as to why would somebody lie. This woman has a history of lying. She makes allegations, she withdraws them. She, in fact, like I said earlier, in one of the records it shows that she has a reputation of saying things just to get attention. This was denied to my client. This was not harmless error. This was a serious, egregious mistake that caused a grave injustice to be inflicted on my client, and he needs to have his conviction reversed, not sent back and remanded.
Counsel, it occurs to me two things. Is there case law that would say we could just reverse and not remand?
No, probably not, but I'm asking for it. I'm going to go for it. Shoot for the moon. Okay?
Then actually what was the other question is this, the CSB records and other evidence that you would have understandably liked to have introduced. Was that sealed somewhere, proffered?
I proffered some of the records at the end of the trial before the judge went to sentencing. Okay, and because the judge and the prosecutor and I had a discussion as to what he would be willing to let me proffer. So I did proffer some of the records, but not to the full extent of what I wanted to offer had he not prevented me from bringing it in the first place.
Of course, counsel, if you'd been able to bring in all that, then she would have been able to testify to a lot of other things,
We were willing to take that chance, Your Honor, because we were convinced that we would have convinced the jury that she was not credible and that my client would get convicted. And to make another point, my client understood from the beginning that the fact that he did not say, what are you talking about, was something I had a problem with in the beginning of the case. But he gave what we thought was a reasonable explanation, and that he was shocked, he was surprised, and he wasn't sure what he should be saying because of the environment he was in. Thank you for your time.
Thank you. All right. Thank you both for your presentations. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on our website and that of the Supreme Court of Ohio.